No, just for all your hands.
Yeah.
So what's going to happen? It'll open up another window.
Well, you know, you're
So
doing
you'll have
programming on
Zoom,
Friday.
and you'll have
You
YouTube,
get
both
five
of
for
which
that.
will be playing.
This is a tough time. Well, that was totally unnecessary.
That's really,
That's very kind.
you can put that on there as a monitor, and you should be in good shape.
And we have the, what's Maduji muted? The speakers are
He
muted?
did. We mute it. You mute the YouTube window,
Okay,
and that does fine because Zoom already is.
it's doing the right
That's what
thing.
Zoom does.
Yeah, right, okay, okay, okay. All right.
You know what?
What?
We should hear more noise.
Should we? We shouldn't.
Let me check.
Yeah,
Yeah, that's fine.
it's all right, okay, cool, okay.
Is it recording? All right.
So. The only mic that's going to YouTube.
Did I need the Zoom?
Okay.
Right. That is this.
No problem.
And so
What I'll do is I'll probably just put it like this, and I'll just hang out here.
that's fine. The only other thing I wanted to tell you is there is an extension on it. And so when you guys sit at the table, you can drag it, move it over there and form it.
Got it. I think we
Just won't
should
be
do
taken
that,
down.
but someone should remember if I don't, to bring the mic to the table when we're done.
Okay. Okay, that's fine. Yeah, did you hear that, Nick? You already said.
This is the only one that connects to Zoom, so when we're done, move down there. You can probably drag it there. I may remember as well.
There's an extension cable on there, so it should reach with no problem.
So where do I need to speak when I do anything? Do I have to?
Well, if you get into the Zoom meeting, it's this mic as in every other classroom.
All right. Do you think
It will reach when you, yes,
Okay.
but I think he's gonna speak from the podium first, and then they're gonna move it over there.
Okay.
So-
That sounds good.
But yeah.
Two is one, one is none.
Absolutely.
Good afternoon, everybody. Welcome. Professor Elon Warman teaches at the Sandra Day O'Connor College of Law at Arizona State University. He writes on administrative law, separation of powers, and constitutionalism. Professor Warman is the author of two books, A Debt Against the Living, An Introduction to Originalism, and most recently, The Second Founding, An Introduction to the 14th Amendment. More recently, Professor Warman's article, Non-Delegation at the Founding, was cited in Justice Neil Gorsuch's concurrence to the decision in NFIB v. OSHA. Professor Steve Sanders teaches constitutional law, family law, and conflicts of law here at Indiana University. He has written for and litigated a number of anti-discrimination cases and is widely cited on the topic. Like Professor Warman, Professor Sanders has written at length about the 14th Amendment and its guarantees of equal protection and due process. On behalf of the Human Rights Campaign, he co-authored an amicus brief to the United States Supreme Court in Obergefell v. Hodges. So please welcome both of them and then Professor Warman.
Thank you. Well, I've never stood behind a podium to do one of these talks, so this will be a compromise. I'll stand to the side of it so the Zoom can pick it up. But thank you for having me here to talk about my new book, The Second Founding, An Introduction to the 14th Amendment. The central claim of the book is that the principal rights-bearing provisions of the amendment's first section, due process of law, the equal protection of the laws, and the privileges and immunities of citizenship are not these broad and open-ended provisions and invitations for modern-day judges to import whatever modern-day extra-textual values they want to put into the text. But neither does the clause, these clauses, I should say, narrowly confine us to what the framers might have thought about particular problems in 1866 or 1868. The clauses are neither so narrow nor so broad. But to make this claim in the book, I should say something about the book's methodology and why it's different than essentially all the other books on the 14th Amendment, or put another way, why it's better than all the other books on the 14th Amendment. So a lot of books on the 14th Amendment resort to plumbing the depths of the legislative history of the 39th Congress, which is thousands of pages long. And the problem of using legislative history and statutory interpretation was famously captured by Judge Harold Leventhal. He said it's kind of like going to a cocktail party, looking over the crowd and picking out just your friends. And when you look into the legislative history, there appear to be stray statements that go sort of any which way and can support any which position. So to give you an example, supporters of incorporation of the Bill of Rights against the states principally rely, not exclusively, but their best evidence for incorporation is one statement from John Bingham, the principal author of the Section 1 of the 14th Amendment, that he made in 1871, 5 years after the drafting of the 14th Amendment. Okay, so there are problems with resorting to legislative history. Others, like Randy Barnett in his new book, look at the anti-slavery constitutional thinkers, the abolitionist thinkers. They say that these thinkers had unorthodox legal theories, but these unorthodox legal theories became sort of the public meaning of the amendment in the 39th Congress and during the ratification process. My claim is altogether different. My claim is that these central rights-bearing provisions, again, due process of law, the protection of the laws, and the privileges and immunities of citizenship, are written in the language of the law. My claim is that each of these provisions has a long antebellum legal history, and through an examination of that legal history, we can ascertain their legal meanings without resort to unorthodox legal theories, without resort to plumbing the depths of the legislative Congress, the legislative debates in the 39th Congress. And what's more, my claim is that these legal meanings directly solve the principal problems confronting the framers of the 39th Congress, namely the comity rights of free Black citizens of northern states. What kind of rights do they have in other states? The widespread mob violence and lack of protection of the laws that was occurring throughout the country, and of course, the discrimination in the infamous Black codes. Okay, well, I can't go through all of that in the 20 minutes I've promised to talk. So in my remaining time, let me make an argument about the Privileges or Immunities Clause specifically. A clause that says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. You may have heard that this clause incorporates the Bill of Rights against the states. This is Michael Kent Curtis's view, Akilah Mars's view, Kurt Lash's view, Randy Barnett's view. In fact, I think it's fair to say that today it is originalist gospel that incorporation of the Bill of Rights against the states, although incorrect under substantive due process, is correct under the original meaning of the Privileges or Immunities Clause. You may have heard a variation of this, that the clause not only incorporates the Bill of Rights against the states, but also guarantees a fundamental minimum of unenumerated, unwritten rights, contract rights, property rights, the stuff of Lochner against New York. I think this is Randy Barnett, his view in his recent book. My claim, so just to be clear, I think this means that the debate today is largely over whether the clause only incorporates the Bill of Rights or also guarantees a certain unenumerated rights. I think the best reading of the clause is that it does neither. It is not a fundamental rights provision at all. Instead, the Privileges or Immunities Clause is an anti-discrimination provision with respect to civil rights under state law. It's an anti-discrimination provision with respect to civil rights under state law. Before I go into the argument, let me explain what I mean by this. I think this means that California can ban handguns. What California can't do is say only white people are allowed to have guns. You can't do that. I think California can prohibit operating a laundromat in a wood building without a license. What California can't do is deny every Chinese applicant who applies a license and grant almost all the white applicants a license. Okay? So those are so that's what it would look like. That's what I claim the clause does. Okay, what's the evidence for this anti-discrimination reading? Well, there are two things I want to talk about, but the largest thing I want to talk about, the most important thing I want to talk about, is the Civil Rights Act of 1866. It is undisputed. Well, I used to say undisputed, and then Kurt Lash and I had a debate, and he's like, well, I dispute it. But other than Kurt Lash, no one disputes that a central objective of the framers of the 39th Congress was to constitutionalize the Civil Rights Act of 1866, which means that the central key to unlocking the amendment's meaning is figuring out what the Civil Rights Act of 1866 accomplished. So what was the Civil Rights Act of 1866? Well, after abolition in the 13th Amendment, after the Civil War, what were the Southern state governments going to do with their newly freed population in the South? Well, perhaps unsurprisingly, they tried to render them to a condition near to slavery as possible without having to call it slavery in the so-called Black Codes. In these Black Codes throughout the South, the Southern government systematically discriminated in the provision of civil rights to the newly freed men and women in the South. So in these Black Codes, the newly freed population, the newly freed people, were not allowed to own real property. White citizens could own real property, but not Black citizens. Black citizens could not assemble to the same extent, or they couldn't assemble at all. Again, something not limiting on white persons. They had to enter into certain kinds of contracts by a day in January each year, lest they be deemed vagrants, a contract provision not applicable to white persons, and they weren't allowed to bear arms. In many of these states, the newly freed population was not allowed to carry dirks, daggers, swords, firearms, or munitions of any kind. Again, a restriction not applicable to white persons. Hence, the Civil Rights Act of 1866 declares that all persons born in the United States and not subject to any foreign power and excluding Indians not taxed, we have to put that aside for present purposes. Otherwise, all persons born in the United States are hereby declared to be citizens of the United States, and such citizens, again, such citizens of the United States, of every race and color, shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, to inherit, purchase, lease, sell, convey, hold real and personal property, as is enjoyed by white citizens. Note what the Civil Rights Act does and doesn't do. It doesn't guarantee any of the rights it lists. It doesn't define any of the civil rights it lists. It merely says whatever contract and property and other civil rights the state affords its white citizens, it must also afford its Black citizens and other citizens free of arbitrary discrimination. Note also the language. We'll come back to this point. But Kurt Lash has said that in the Privileges or Immunities Clause, the phrase privileges or immunities of citizens of the United States is a term of art referencing privileges and immunities in the United States Constitution, the Bill of Rights. But note how it's used in the Civil Rights Act. The Civil Rights Act declares persons born here to be citizens of the United States and declares that such citizens of the United States are hereby entitled to equality in civil rights under state law. Consider Andrew Johnson's veto message. Andrew Johnson vetoed the bill, he said, because it contains an enumeration of those rights to be enjoyed by those classes so made citizens, again, citizens of the United States. Now, Andrew Johnson vetoed the bill precisely because those privileges of citizens of the United States were civil rights under state law. And Andrew Johnson believed that Congress did not have a federal power to interfere with the civil rights legislation in the states. Look at Article 1, Section 8 of the Constitution. 13th Amendment may be more plausible, but it's unclear where Congress gets the power to interfere with the civil rights legislation of the states and to modify the civil rights legislation in the states. But that's precisely why we needed the 14th Amendment. We needed the 14th Amendment to constitutionalize the Civil Rights Act in two respects. One was we needed to actually give Congress a grant of power so it could enact legislation like the Civil Rights Act of 1866. But that wasn't enough. What happens when the Democrats take charge, as they did in 1875? What's to stop them from repealing the civil rights legislation of the Republican-led Congress? So they needed to enshrine the requirements to embed the requirements of the Civil Rights Bill in the fundamental law itself, in the eternal firmament of the Constitution, in the words of future US President James Garfield, who was then a representative in the House. So the question is, which clause of Section 1 of the 14th Amendment does the necessary work of constitutionalizing the Civil Rights Act of 1866? Well, I submit the Privileges or Immunities Clause for at least 4 reasons. One, note the parallel to the Civil Rights Act. The Civil Rights Act begins with a declaration of United States citizenship and then says citizens of the United States are entitled to equality and civil rights under state law. How does the 14th Amendment start? All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Note also the parallel to the Privileges and Immunities Clause of the original Constitution. Article 4, Section 2 has a clause that says the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. What did this clause do? It was often known as the Comity Clause because it required the states to treat citizens of other states as citizens and not as foreigners. What did this mean? This means when a citizen of Massachusetts is traveling to Georgia for work or pleasure or what have you, the citizen, Georgia is not supposed to treat that citizen of Massachusetts as a foreigner, as an alien, but instead must give the same privileges and immunities, the same civil rights that South Carolina gives or Georgia gives its own citizens. In other words, the Privileges and Immunities Clause was widely accepted, understood to be an interstate non-discrimination provision. Well, if I'm right, the Privileges or Immunities Clause does for intrastate discrimination, prohibits it, right? What the Privileges and Immunities Clause did for intrastate discrimination. Note also that the language does the necessary work. The word abridge often was used in a discriminatory way, right? To mean someone has a lesser set of rights than others, an abridged set of rights compared to others. The hiccup is usually privileges and immunities of citizens of the United States, which, as I mentioned, Kurt Lash and others say this is a reference to the federal Constitution. But wait a minute, that reasoning collapses upon a moment's reflection. Because United States citizens have privileges and immunities from multiple sources of law. Yes, we have privileges and immunities by virtue of the federal Constitution, but you know where else we have privileges and immunities? Federal statute law. You had to be a citizen of the United States to be able to captain a vessel enrolled in the coasting trade. You had to be a citizen of the United States to get a passport. What about patent laws? Federal laws create all sorts of privileges and immunities of United States citizens. And United States citizens also have privileges and immunities by virtue of state law, state constitutions, state legislation, state and even general common law. So it doesn't make sense to limit the phrase privileges and immunities of citizens of the United States to a mere subset of the privileges and immunities of US citizens. It makes much more sense to say that they refer to those privileges and immunities of United States citizens that it is within the power of the states to abridge in the first place. Civil rights under state law. Now, maybe this is the clincher, but I eschewed reliance on legislative history, so I saved this kind of till the end. But numerous members of Congress specifically connected the Privileges or Immunities Clause with the task of constitutionalizing the Civil Rights Act of 1866, compared to only one that I could find who said, well, I don't know, equal protection, maybe that's what does it. Okay, that was Jacob Howard, who was confused for other reasons, I think. But this takes me to my next point, which is what about the Equal Protection Clause? After all, if the Equal Protection Clause is what guarantees equal civil rights, then isn't my reading of the Privileges or Immunities Clause superfluous? It couldn't be right. Well, I hate to break it to you, but equal protection does not mean what you all learned it means in common law. Equal protection of the laws does not require equal laws. It does not require equal rights. It requires equality in something very important, but much narrower, the protection of the laws. What was the protection of the laws? Well, in short, the protection of the laws was the flip side of due process of law. Due process of law said whatever rights you have, however unequal they are, however miserly they are, We won't take away your rights. You can enjoy those rights. And the government will only take away your rights pursuant to established law. And if you violated that established law, we'll adjudicate that violation according to established and known procedures. That's it. You can tell, by the way, by this definition, I don't think there's a substantive due process, but I have to leave something for you to read in the book. So I won't say more about that at the moment. What is the protection of the laws? The protection of the laws is the flip side. It was the legal protection the government had to give its citizens against private interference with their private rights, interference from other private citizens. When your neighbor trespasses against you, when someone commits a battery against you or an assault or some other tort, they are interfering with your enjoyment and exercise of your civil rights. So the protection of the laws was the legal protection the government had to give against private interference with private rights, namely two requirements of this. One was judicial remedies. There had to be remedies available against other persons, other citizens who were violating your rights. And the other is physical protection from violence, from private violence. Mob rule, Lynch's law, was the quintessential violation of the protection of the laws in the antebellum period. It's all over the literature. Mob rules and the failure of the state to protect against mobs was the quintessential failure to provide protection of the laws. It authorized private violence against you, interfering with the enjoyment of your rights. So the Equal Protection of the Laws Clause does not constitutionalize the Civil Rights Act of 1866 because it doesn't require equal laws. Whatever rights you have, however unequal they are, due process says only the government will take them away and only pursuant to established laws and established procedures. And the protection of the law says whatever rights you have, we will make sure you can enjoy and exercise those rights free from interference from the Ku Klux Klan, for example. So if I'm right, then only the Privileges or Immunities Clause is left. Only the Privileges or Immunities Clause succeeds in constitutionalizing the Civil Rights Act of 1866. Okay, let me say one more thing and then one implication. The second thing I want to talk about is the evidence that Akilah Marr, Michael King Curtis, and others talk about that supposedly point to incorporation. They say, well, look at all the violations of free speech, free press in the antebellum period. Look at the widespread violation of these civil liberties guaranteed in the Bill of Rights in the South. They say this somehow points to the need to incorporate the Bill of Rights. No, it doesn't. Why? Because every single state constitution had a free speech equivalent. Every single state constitution guaranteed freedom of the press. Every single state allowed white persons to own guns. The problem was not that the states did not guarantee these rights or protect these rights. The problem was that the states denied these rights to Black citizens, or to abolitionists, or to unionists, or to Northerners. Well, the anti-discrimination reading of the Privileges or Immunities Clause solves this problem because freedom of press, right to bear arms, are privileges and immunities under state law that white persons enjoy. Therefore, the state must now afford those and extend those rights equally to their Black citizens. Okay. Let me say one thing, since I actually don't know when I started, so maybe I'm not going over, but in any event, let me just say one more, just one implication. I think my reading, this reading, the correct reading of the Privileges or Immunities Clause is the only reading that gets us Brown v. Board of Education as an originalist matter. Is public education a civil right under state law? Well, in 1954, it was in Kansas. It doesn't matter whether it was elsewhere, whether it was in 1868. In 1954, Kansas offered this right to its white citizens. It is a privilege under state law. The clause reaches it. The question then becomes whether separate schools is in fact an abridgment of the privileges and immunities of the state's Black citizens. Well, forgive me for thinking that this was an easy case. Forgive me for agreeing with Justice Harlan in his dissent in Plessy v. Ferguson, who said, we all know that the segregation laws were not enacted to keep the white man away from the Black man so much as to keep the Black away from the white. Or forgive me for thinking that Professor Charles Black, the legendary Yale law professor who grew up in Texas, just after Brown v. Board was decided, wrote an article defending Brown v. Board, He thought it was an easy case. Why? He said, because as soon as judges open their eyes to what every Texas schoolboy knows, he was a Texas schoolboy, that the Jim Crow laws were not enacted to keep the races separate and happy and equal, but precisely to keep one race in subordination to another, then the separate schools, separate facilities, segregation altogether is part of a caste system specifically implemented to abridge the privileges and immunities of Black citizens, to give them a lesser set of rights from white citizens. I think Brown v. Board was actually a relatively easy case. Incorporation doesn't get us there. What is incorporation do? Incorporation has nothing to do with public education. Substantive due process, public education, a fundamental right. Give me a break. I mean, we might all think it is today, but certainly not fundamental rights in any understanding of modern substantive due process doctrine. Equal protection doesn't get us there under the original meaning. Procedural due process doesn't get us there. Randy Barnett's unenumerated rights reading doesn't get us there. The privileges and immunities clause, the anti-discrimination reading, is the only one that gets us to Brown v. Board. So let me just conclude by saying, I think not only is my reading the best reading of the privileges or immunities clause, maybe it's the reading we should also like the best. Okay, that's all I have to say. I will say one more, in case I forget. I brought half a dozen books with me. I sell them at my author discount. It's like $5, so it's $15. I'm a millennial, so I have a credit card reader. I can do Venmo. And let me just say, I'm happy to inscribe them for you, but I cannot promise that I'll increase the value of the book. And for that matter, I can't promise it will decrease it either, but I'll hang around after we're done as long as I can, in case anyone wants them. That's what I have to say. Thank you for your time.
I'm going to sit here, but I think I just need to move the Zoom microphone so it'll pick up. Do you mind having this?
No.
Sort of in front of you. That should be okay. So I don't identify as an originalist, but I'm fascinated by originalism because it really is, if you studied sort of constitutional theory, a really sort of roiling symposium. My sense is that most originalists are so convinced that they don't need to seriously engage with sort of the dynamic constitutional, sort of living constitutional argument. They're so convinced that's all sort of just enactment of modern day extra textual values that they don't need to take that seriously. What's really fun is to talk about how the originalists disagree among each other. And so there are fascinating and legitimate academic debates about this. I've sort of my sort of early sense was there are the sort of paleo-originalists and the new originalists. The paleo-originalists sort of believe both, we have to seek the original meaning of the provision, but also limit ourselves to the original anticipated application. Whereas the sort of new originalists, the younger generation of scholars say, we just have to be faithful to the original meaning. The application in modern circumstances can be something that the framers couldn't have imagined, but that's okay. So that's why you have originalist scholars who, under other methodologies, can say Obergefell or even Roe versus Wade can be justified as originalist because the original meaning of the 14th Amendment is a sort of anti-caste, anti-subordination, anti-class legislation, and anti-abortion laws and gay marriage laws are violations of that. So anyway, so as I said, I think there's a fascinating variety. My sense is, and I'm just saying this in an uninformed way, that Professor Werman may be more in the sort of new originalist camp, in that, as I understand his methodology, he's looking at it doesn't matter if they thought that schools, segregation was okay, and in the 1860s, we're looking at a modern application here. So it's the we don't care about whether the people who framed the provision could have imagined it applying to a particular modern application. But I think what I'm concerned about is the sharply limited way in which Professor Werman looks at what the original intended meaning of the provision was. I was able to skim through his book anyway over the weekend, and you heard his presentation. He would sort of what he would do with substantive due process. No such thing doesn't exist. That's accepted wisdom among pretty much all originalists. His understanding of the Equal Protection Clause does seem radically narrower than any other originalist that I'm aware of. So there's that. So he sort of told us that the Equal Protection Clause and the Due Process Clauses really do very little work in terms of what we might think they do in protecting rights and liberties. So what we're left with is the Privileges and Immunities Clause. Privileges or Immunities Clause, sorry, I'm going to fall into that. And so he's determined what was the original immediate problem it was intended to solve. That is, making the Civil Rights Act of 1866 compatible with the Constitution. That's fine, but I think this just gets to my first sort of objection to originalism is that, is there any evidence that the framers of the 14th Amendment, solving that was the sort of immediate problem they sought to solve, intended its meaning to never be anything more than that. So, I mean, my philosophy of constitutional interpretation is much more like what John Marshall himself, a Federalist, at least a part of the Federalist Party, said that a constitution is intended to endure and be adapted to various crises in human affairs, whereas originalism sort of locks us into what was the understood meaning at the time, or what problem was the provision intended to resolve. Professor Werman says his approach is to look at language, not legislative history, original meanings in antebellum law, the language of the law, and so forth. The Privileges and Immunities Clause is an anti-discrimination provision, he says, with respect to state-defined rights and that state's own citizens. And so if a state grants a right under this reading of privileges or immunities, it must be extended to all citizens, but it's free to just abolish the right. So apparently federal citizenship brings no rights against the states, except the right to say that a state isn't enforcing its own constitution or laws in an equal and non-discriminatory way. I hope I haven't done too much violence to the argument so far. So, as I said,
music to my ears.
I think all of the sort of history and the engagement that you'll find in the book and in Professor Werman's talk is great. It's a fascinating intellectual exercise. It illustrates how originalists are in very interesting and sort of nuanced conversation with other originalists. My concern is there's a passage in Professor Werman's book where he talks about how the contemporary appeal of this idea is compelling. And that's what I want to take issue with, is exploring some of the implications of this understanding of privileges or immunities and this understanding of incorporation. And again, I hope he'll correct me if I'm getting something wrong. So for starters, obviously, there would be sort of no right to privacy and everything that entails. That's because we've gotten rid of substantive due process. So no federal constitutional right to abortion, contraception, the parent-child relationship. And you might say, well, that's the things that the ACS liberal people care about. But the suit that was litigated against IU about its vaccine mandate last year, which was brought by a dyed-in-the-wool Republican social conservative, relied on the idea that the 14th Amendment gives you a fundamental right to not have your body invaded by things you don't want to be invaded by. Well, that would be out the window. So I think there's reason for both liberals and conservatives to be concerned about that. A state would be free to criminalize sodomy as long as it did so on an equal basis, I guess, men and women or gays and straights. There would be no appeal to dignity or realms of personal liberty. The government can't enter those sorts of constitutional values the court has exposited in connection with the Due Process Clause. The case about Brown in the book, as I read it, seemed a little more tentative than Professor Werman said here today. He said this at least is a plausible reading of Brown. Because in part, at the time of the 14th Amendment, there was this distinction about civil rights versus political rights. Civil rights were protected, political rights were not. And there's some question about whether education would have been categorized as a civil or political right. Okay, let's say this methodology gets us to Brown versus Board of Education. What it doesn't get you to is any right to vote. There would be no federally protected right to vote whatsoever under the Constitution, because the right to vote was seen as a political right at the time, not a civil right. So under Professor Werman's methodology, that takes it out of any federal constitutional protection. there would be a right to gay marriage because marriage is a sort of state licensing scheme that states have always done, and it's a civil right, and so it can't be denied. So it would get us to gay marriage, but no constitutional right to vote. I mean, I'm not saying that's incompatible, but it leads to interesting consequences. The states, he says, would be free to experiment with some of the more controversial rights in the Bill of Rights and to push back against the Supreme Court's more controversial interpretations of them. And so, as he said, all state constitutions protect speech, religion, but there are potentially 50 different interpretations and understandings of what is speech, what is free exercise. Freedom of the press, does that mean that there's a sort of shield, a special protection for journalists doing their jobs or not? There would be 50 different views of that. Refusing to bake a cake for a gay wedding or taking a gay date to the prom, are those expressive conduct or an exercise of speech? The Supreme Court has at least said in some contexts, there's a plausible argument that those are First Amendment rights, but would states regard that kind of conduct as protected by the First Amendment? All states, or by their free speech provisions or free exercise provisions, all states prohibit unreasonable searches and seizures, but the devil is in the details. What does that mean? What are the exceptions? There would be no Fourth Amendment Miranda right unless a state individually, state by state, decided it would be a good idea. But since that's a matter of federal constitutional law, it wouldn't exist. 47 states, not even all 50, prohibit cruel and unusual punishment. Again, what does that mean? The Supreme Court has said that part of cruel and unusual punishment means protection against harms inflicted by other inmates through a gross neglect, deliberate indifference, harm to lack of medical care, and so forth. Would states agree that that's a huge, fruitful area of Section 1983 in prison litigation? Would states agree that's what, would the 47 states that have cruel and unusual punishment laws agree that kind of thing is protected or not? So only 33 states, I think my count is right, say specifically that keeping and bearing arms is an individual right. If this is a sort of pro-Second Amendment crowd, your ears probably perked up when Professor Werman said California could abolish gun rights. So this is sort of fun. It shows that it shows originalism doesn't always produce quote unquote conservative outcomes. But I think my concern is that's different than arguing that this provides a sort of coherent vision of what a constitution should mean and do to create the kind of society that we want to live in. It seems as though if you have, how could the Supreme Court, I assume the Supreme Court could not impose a uniform meaning about what is or is not speech, what is or is not free exercise, what is or is not cruel and unusual punishment, what's the test to determine whether your right to keep and bear arms has been infringed or not? Do concealed carry laws do that? If all of these rights emanate from federal law and not from state law, I assume that the federal Supreme Court could not impose uniform meaning and standards on them. And moreover, most of these rights, to the extent they already exist in state law, are really underdeveloped. Most states just say, our understanding of our free speech provision is coextensive with what the Supreme Court says about the First Amendment. So this is an interesting puzzle. If we've decided that all of the laws incorporating the First Amendment against states, which have provided these detailed doctrines that you could spend a semester studying the First Amendment, if all of that was sort of illegitimate because it was never intended to be applied to the states, what happens to the states that base their understandings of these provisions on federal constitutional law? You have potentially 50 different ideas about free speech, gun rights, religion, unreasonable searches, 50 different philosophies of constitutional interpretation. The only thing the federal courts or the Supreme Court can do is say, well, you can't discriminate. If you give it to one group, you have to give the right to the other group. But the Supreme Court can't say what qualifies as exercise of religion or establishment of religion. So this sounds like a full employment act for lawyers. That there would be a rich new growth area in state constitutional law with 50 different state constitutions, potentially meaning 50 different things when it comes to all of these important constitutional guarantees. I guess my worry is, wouldn't that push us further apart? Is that what wouldn't vastly magnify the kind of red versus blue state political differences we already suffer? We already talk about the possibility of civil war, and the red states can go their way, the blue states can go their way. Again, unless I'm misunderstanding Professor Werman's argument about how we would push all of these controversial constitutional debates down to the state level and potentially have this kind of fragmentation of constitutional law, I'm not sure that provides a society that gives us the stability and the uniform meaning of federal law and individual rights that we need. He may be entirely right about what the Privileges and Immunities Clause was entitled to do. Is that the same thing as saying it provides a compelling understanding that we should want to live under today? And again, I think the work is interesting. I'm not meaning to be as harsh as this probably comes across, but I was sort of struck in reading the book by what I think there are more books to be written just laying out, how would all of these issues be adjudicated at the state level. So again, I'm always happy to be here, always happy when speakers like Professor Werman come here, and thanks for the opportunity to give a few brief thoughts.
Thank you. If I may just respond to it briefly, it just reminds me a bit about the commentary at Boston College that I went and spoke there, where the professor there, Dan Farman, accused me of being scholastic. This is just so academic, like it's never going to happen anyway, and would it really be so good? And my response to that is, the great part about our jobs is we get paid just the same.
Oh, absolutely. I'm not disagreeing.
I just think this is fun and interesting. Now, having said that, I actually embrace almost every characterization. I think there were some things were wrong. Like if you get Obergefell, which I think you do, at least is plausible, I think same-sex sodomy has to follow along with that. So that's tricky. What's more polarizing? A Supreme Court that by a 5-4 vote tells blue states on the basis of a contested reading of the Second Amendment that they can't experiment with social policy and handguns. Supreme Court by a 5-4 vote telling red states that they can't ban flag burnings. What's more polarizing? That, or where each state sort of decides for itself on these questions. Now, why I'm convinced that I'm right about this reading, notwithstanding all the really intelligent people that have said that the 14th Amendment was also a fundamental guarantee of certain rights, whether in the Bill of Rights or elsewhere, is because in the antebellum period, there was no question that it was widely understood that all free governments existed to secure natural rights, and therefore the kinds of rights secured by most of the Bill of Rights, in fact, were secured by most free governments, including the state constitution. The assumption was these governments secured them. All free governments secured rights, but they could modify and regulate those rights according to their particular social customs and usages, and so on. So that idea that all free governments must secure these rights and did secure these rights coexisted in the antebellum period with the idea that the states retained discretion to define and regulate and modify those rights. That's why I think there's no fundamental rights guarantee, because every time they talked about, all free governments provide this, no free government can deny that. They were talking about political theory. They weren't talking specifically about the 14th Amendment or the Privileges or Immunities Clause. But let's suppose I'm wrong about that. Let's suppose that the Privileges or Immunities Clause does bake into it that minimum fundamental rights threshold that no state can go below, that all free governments must secure. I agree, all free governments must allow political speech and cannot punish it before or after the fact. I think that is the core of the freedom of speech. No free government can remain free without that. But must all free governments have the same answer about whether flag burning should be prohibited? About whether having a protest at a soldier's funeral that intentionally inflicts emotional distress should be protected? Must all free governments have the same free speech policy about students in schools? Must they all have the same policy about advertising violent video games? Must all free governments have the same answer to the question of whether it's You can't prohibit someone from stealing valor, from pretending to having a Medal of Honor when they don't. All cases in which the Supreme Court said states can't do X, Y, and Z because that's what the First Amendment means. Are you kidding me? Are you kidding me? Would the world be so bad if we let, even assuming this baseline, right, letting states debate those issues and decide for themselves? And as Professor Sanders said, there's something in it for everyone. Liberals, conservative, California can experiment with handguns. I suppose Texas can abolish Miranda warnings. I think they can abolish the exclusionary rule, which are all made up anyway, right? So like, would this vision really be so terrible? Would it really be so terrible? I don't know. I'm inclined to think it wouldn't be bad at all, actually. Right to vote, I'll just say one thing about that. Yes, it's true. The one thing I must give up, other than incorporation, which I'm happy to give up, okay, is political rights, which makes sense, right? Because why would we need the 15th Amendment? Why do we need the 19th Amendment if the Privileges or Immunities Clause included political rights? It just wouldn't make any sense, right? Political rights include the right to vote, to hold office, and to serve on juries historically. Now, whether you can get juries another way through due process or protections, actually, I think you could make a plausible case for that. So let's focus on political rights that aren't like holding office, voting, and so on. I think this means we lose one person, one vote. I grant that. And this is shocking and horrifying for people. Why? Because voting districts, political rights, unless you can find a home for it in the 15th Amendment or the 19th Amendment or the 26th Amendment, I think they go out the window. But would that be so crazy? Again, I don't know. Call me really old school in this case, but we give a couple 100,000 people in Wyoming much more voting power in the United States Senate than several million people in California. Why? Well, because if California wants to experiment with crazy policy, then California can impose that crazy policy on Californians. But if you want to ban hunting or ban fracking or something that affects the industry in Montana or what have you, then maybe you should get the buy-in from the citizens there before you abolish their culture and their values and their sort of politics, a different point of view. Well, the same thing used to be at the state level. If San Francisco or LA want to do something crazy, then impose it as a city ordinance, right? But if you want to do something that affects the countryside, maybe you should get their representative on board, even if the representative has fewer voters compared to the other representatives in the cities or something like that. I don't know, would that be such a crazy world? At this point, usually some people are like, yes, right? But I don't know, just food for thought. By the way, okay, last thing, and I promise, last thing, crazy world. Could they just abolish property? Could they just abolish contract or abolish speech, right? This goes back to whether the free government line is even a line at all. Okay, well, I'm not gonna lose sleep over that. Why? Because it's Caroline Products footnote 4. This is consistent with Caroline Products footnote 4. Why? Because if the state abolishes property or says, we believe capitalism is evil, no one can work for wages more than 4 hours in a day. Don't want to do that, fine. As long as it imposes it equally on everybody, then isn't the political process exactly what we have to solve those kinds of problems, right? We're supposed to step in when the political process breaks down and targets minorities by discriminating. So I think, okay, let them try abolishing property. It's not going to happen, right? Because you'd have to abolish it for everybody, and obviously that's not going to happen, right? So I don't know. I maybe it's crazy. Call me crazy. But maybe it'll be
One last
peachy
really
too.
fast observation. I don't want to give rebuttals and sir rebuttals, but I don't know if Professor Werman would identify as a libertarian, sort of that part of the FedSoc, that wing of FedSoc. I guess it's been my observation that at least political sort of Federalist Society libertarians, William Silman and others, who are sort of all about like let every state kind of have do what it wants. States as laboratories of democracy. I just taught that in common law today. I believe in that, but I think it overestimates the extent to which people are free to. The underlying assumption is, well, people just vote with their freedom. People in Wyoming get what's right for them, and people in California get what's right for them. But to what extent is that like you vote with your feet idea really forward? Or like a lot of you are here for 3 years in Indiana because you're here to get an education, but you're subject to the laws and rules here in Indiana. And they may be completely different than the values you grew up with or your home or where you plan to work and so forth, but you're subject to our laws. People are stuck where they live under laws they may or may not like for all sorts of reasons that are beyond their control. So I don't say it's crazy, But I do think the underlying assumption is like people are always part of the political culture of a state for like all of their lives, or they choose to be there, or they've chosen to relocate there because of the political environment and what the state says its constitution means, as opposed to school or work or career, whether they have to take care of a parent or something else, which is why it makes, for some very fundamental things like this, which is why it makes more sense to have nationwide understandings about what law protects.
Well, as one of my mentors said about another paper that I wrote, I don't know if this is crazy or right, or maybe it's a bit of both. Now, in that case, it was crazy and probably wrong, but this can be both crazy and right. So, happy to take questions, as long as they're nice questions. Fair enough. This one's for you then. That's okay. Go ahead.
From your summary, if I understand your argument against incorporation, it's because state constitutions already in their own way enshrine the same rights. But given that state constitutions are so much more readily adopted, amended or changed. I grew up in Florida and we have about 15 different constitutional amendments every general election, maybe a third of them pass. Given that these state constitutions are a lot less stable, and theoretically, if one state were to remove a protection to free speech or religious expression from its constitution, what method or cause to action would a US citizen have to protect the rights of their fellow US citizen, a citizen of the same republic that lived a few miles over a state line, that no longer had access to a right that is assumed to be protected by any international standard of democracy? Would the protection just be that it's very unlikely that a state would ever do this? Would they have something outside the 14th Amendment? And if the reasoning is just that a state would never do that, does that mean that the only rights that need to be enshrined are the ones that at the present moment seem likely to be infringed?
It's an excellent question. And the answer is yes, I think it's unlikely to ever happen. Why? Because of your right to vote, right? That is the right that you can exercise. If 50, I don't know how many people live in Florida, but whatever. If 51% of the Florida population wants to prohibit their own right to speak on topics, their own, okay, then you know what? I shall let you experiment.
60% of the people motivated enough to show up.
Yeah,
vote,
for sure.
Which might be 30%.
Yeah, that's fair. Yes, there's a risk of that, right? But even today, well, we've got, for all the proposals that we talk about, hate speech and things like that, right? No one seriously says we're going to abolish the core of the First Amendment. No one, the Second Amendment is the closest thing states would be willing to come to abolish. And you know what? I think I'm okay with that. I think I'm okay with some states doing what I think is really stupid, to leave other states free to do things that aren't stupid. And I'm okay with that. I'm okay with that because I ultimately believe, as Publius did, in the capacity of mankind for self-government, right? That is what our whole experiment depends upon, right? So, yeah, I'm not troubled by that. I'm just not troubled by that the way you are. And the way most people are. Most people are troubled like you are, troubled by this, right? I'm just not. That was a pretty cutting question though. So I don't know. Violated the rules. There's one over there, but yeah. Yeah.
I'd like to get just help clarify your reasoning. Looking at the 14th Amendment, it says, persons born and naturalized are citizens of the United States and the state thereof. And then the next sentence says, no state shall deprive privileges or immunities of United States citizens. So doesn't that seem to actually allow incorporations through that clause, since it looks like it would be, abridging a federal right rather than a state right?
Yeah, it's an excellent question. There's a textual hiccup, right, which is sort of explained. There's a historical explanation for it, right, that the Citizenship Clause declares both United States citizenship and state citizenship, right? And then it says privileges or immunities of citizens of the United States. Now, of course, citizens of the United States have privileges and immunities as citizens of the United States and their United States citizenship makes them state citizens too. So this debate comes from the Comity Clause debates. There were free Black citizens of northern states. The Comity Clause seems to require the southern states to give them the same privileges and immunities as citizens of those states. Well, was South Carolina about to give free Black citizens of northern states the rights of white citizens in South Carolina? They said no. What was the argument? Well, you may be a citizen of North Carolina or a citizen of Massachusetts, but you're not a citizen of the United States within the meaning of citizenship as used in Article 4, Section 2 of the Constitution, right? And so what the 14th Amendment does is say they are citizens of the United States and as citizens of the United States. That means they're also, by birthright citizenship or whatever, citizens in those. You can't just say, okay, but now you're a citizen of the United States, but not a citizen of my state, right? To deny them privileges and immunities of state citizenship, okay? But the whole point of the 14th Amendment was to staple, not to disentangle state and national citizenship. The whole point was to staple them together. When the argument in the antebellum period was, yeah, you may be a citizen of Massachusetts, but you're not a citizen of the United States, such that I have to treat you as a citizen when you're in South Carolina. The whole point of it was to staple them together. Now, it's true. In 1871, John Bingham, the principal author, said, we distinguished state citizenship from national citizenship, therefore I intended to incorporate the Bill of Rights. He says exactly what you said in 1871. The problem is 6 weeks earlier, he said the exact opposite. 6 weeks earlier, as the author of a Judiciary Committee report on whether Victoria Woodhull could vote, she petitioned to say, we have the right to vote. He said, political rights aren't included because in the opinion of the committee, this is John Bingham writing, the privileges and immunities of citizens of the United States refers to none other than the privileges and immunities of Article 4, Section 2 of the Constitution, those privileges under state law. No one disentangled state from national citizenship. The whole point was, the whole argument of the Northerners was that these free Black citizens are citizens of the United States, in addition to being state citizens, and therefore are entitled to privileges in the Constitution, right? And privileges under state law. And by the way, Article 4, which guarantees privileges under state law, is itself a privilege of United States citizenship in the federal Constitution, isn't it? Anyway, that's probably much longer answer that. I wish there was a clean way to answer that, but yes, it's complicated because John Bingham said the same thing in 1871. You know who else was there in 1871? James Garfield. And you know what he said? He responded to John Bingham the next day. He said, my colleague can make, but he cannot unmake history. I went back through the whole congressional globe and we did not say any of this. No one thought any of this at the time. The whole objective was to target the unequal legislation of the states. That's what he said. And I think he was right. That's a really hard question. These are the hardest questions I've gotten like all year, actually. Yeah.
Maybe spend some time clarifying the role of the federal Congress in correcting the 50 state legislatures' civil rights legislation.
So the enforcement power, okay, it's tricky. I actually don't fully know what I think about the enforcement power yet. Whatever I think about it must mean that the 1866 Civil Rights Act is constitutional, right? But what I will say something about the Equal Protection Clause, because you actually said something earlier that it is narrow, right? Radically narrower in one respect, but in another, it's actually more expansive. Remember the DeShaney case where a woman called the police and said, my husband, I think it was my husband, he is going to kill me. Send officers, please. Like there was a restraining order. He was going to violate. Or said, oh, something, right.
Beating the kid to point.
And they just neglected to provide, I don't know, protection of the laws. If there was a widespread failure of the protection of the laws, could Congress step in and supply protection of the laws? For example, in Morrison v. United States, by providing a cause of action for women who have had acts of violence committed against them. I think Shelby County is also easier to support under my reading of protection because it's, well, I mean, that's a 15th Amendment thing, I think, it's different. So I think we get maybe the Violence of Women Against Women Act. I think DeShaney should come out the other way. So Congress has a much more robust enforcement power than you might think. I tried to say enough to make sure I answered your questions as I saw you coming back. Well, I don't know if there's a class in here after, but happy to just stick around, take questions. And as I said, I take them Very moving lads. And I'm happy to stick around. Thank you. Am I crazy or am I right? Maybe a little bit of both.
I mean, like I said, I think you separate, the scholastic academic argument from what so to be comfortable with the implications, it does strike me as you have an extremely high degree of faith